And I don't want to jump ahead to your bad faith. I don't know if you're going to argue the bad faith case of this or not. But, and I know you contend that there's no bad faith, and you make similar arguments, I guess. But how is it, maybe I shouldn't ask how is it, but the judge found at least, and find, there's at least 12 mentions in her statement of decision of bad faith or breach of the covenant of good faith and fair dealing.
Yikes, that didn't sound too good. Peace, y'all. This is Seneca Scott, your host of Gotham Oakland, where we cut through the fog of dysfunction and false virtue signaling to confront the reality of our city's decline and the forces behind it. Today, we're digging into a saga that bled Oakland of millions of dollars, gutted public trust, and turned coal, yes, coal, into a totem of moral panic. The Oakland Bulk and Oversight Terminal, or OBOT for short. Let's rewind. In 2016, under Mayor Libby Schaaf, the city signed a 66-year lease with OBOT, Phil Tagami's development group, to build a bulk commodities terminal at the Port of Oakland. A mega deal full of risk and reward. OBOT would take on the financial burden and regulatory challenges in exchange for a chance to revitalize stagnant public land and create real jobs and real revenue. But the deal had one fatal flaw. It depended on a city that kept its word. Instead, the city reneged like a bad space partner. Not because the facts changed, but because the politics did. What followed was a familiar Oakland playbook. Performative outrage, a rush coal ordinance, a multi-year smear campaign, branding OBOT as a threat to our city's sacred cow, social justice. But it wasn't policy, it was posturing, and the court saw right through it. Last week's appeal hearing made that crystal clear. Oakland's lawyer, grasping at straws, was gently but firmly rebuked by a judge who pointed to a 95-page ruling documenting the city's misconduct, stalling permits, ignoring experts, and blocking rail access. This wasn't just bureaucratic incompetence, it was a deliberate breach of good faith. Sound familiar? This is much, much bigger than a contract dispute. This is a case study in how moral vanity corrupts governments. A shadowy activist group, No Coal in Oakland, led a crusade with zero accountability and no skin in the game. They pushed loyalty pledges from elected officials. They divided neighbors. They made coal a litmus test for moral purity. Meanwhile, City Hall torched a generational opportunity, and they blame everyone but itself for the fallout. Here is the cost. Tens of millions in legal fees, hundreds of lost jobs, a $1 billion lawsuit, and a bankruptcy that's now set since the case in Kentucky, all for political gestures that collapsed the moment it met a courtroom. Oakland didn't just break a contract, it broke its credibility. When a city treats agreement like political conveniences, it doesn't just lose lawsuits, it loses public trust and any hopes of future serious investments. Anyway, this is Gotham Oakland, where we hold up the mirror because coal isn't killing our city, cowardice is. Now, if you value this kind of straight talk, free of spin and untethered from a donor class's nefarious agendas, please comment, subscribe, and repost to feed the algorithmic beast. Share it with a friend and ask them to do the following as well. And yes, I finally set up a VENMO. I've been had a VENMO, but I'm going to put it in here. You see, I've been so focused on digging up the truth, I forgot to leave a shovel out for the folks who want to help. If you believe in Gotham Oakland, please contribute what you can. This program takes time, energy, and grit, and your support makes it sustainable. Thanks for riding with us. Now, back to the show. In 2016, the City of Oakland signed a 66-year ground lease with OBOT, seasoned developer, to build a bulk terminal on city land. We've been through that. 500 pages of promises, deadlines, and ambition. Now, what's the city's story? OBOT knew the risk, especially around coal, and dropped the ball. Sounds airtight, right? Except the trial courts called BS. and the appeal showing Oakland lies in hot water. I'm going to start it at the beginning. I'm going to cut through it and sort of narrate it along the way so you can understand exactly what's happening here.
For the city.
Again, Danielle Leonard from Altshuler Verzon on behalf of the City of Oakland. In February of 2016, the City of Oakland and a very experienced real estate developer entered into a heavily negotiated 66-year lease. This is it. It's volume 6 of the appendix. This is the ground lease that is at the heart of this case. It's 500 pages of carefully negotiated terms. Extensively negotiated terms that balance 3 things, really: risk, responsibility, and reward. OBOT went into this with eyes wide open and assumed all the risk of regulatory uncertainty and market uncertainty when it agreed, by very specific deadlines, to start construction of a bulk terminal on the city's land. Eyes wide open about the fact that the city was going to legislate with respect to coal. It knew that at the time that it entered into the contract and agreed to those deadlines. Article 6, section 6.2.1 is where you will find the steps that OBOT agreed to move this through the process. And
Ms. Leonard, you said that OBOT knew that at the time that it entered the contract that Oakland was considering something to do with regulating coal. What are you referring to, and where is that in the record?
So that is, I'm referring to, there was already a September 2015 hearing in which the City of Oakland started the legislative process with respect to coal. Everyone knew that there was brewing a pretty serious dispute over the city's ability to legislate with respect to coal. This deal was done because the parties agreed to set that to the side and move forward anyway.
How do you lie?
That's
The
the
development
balance.
agreement was earlier than 2015. So how does that play into this argument? That is, weren't they already basically committed, or could they have, how did that work?
Article 5 specifically says that nothing the city can do in its legislative or regulatory capacity would interfere with OBOT's deadlines. OBOT agreed to all of that. That's the balance of risk, responsibility, and reward.
Listening to you and your eloquence and your emotion, how is it that a judge listening to all this for weeks writes a 95-page statement of decision rejecting your position basically every step of the way? I mean, are you going to get to what Judge Wise found and decided, or are you just going to talk about reward and the size of the lease?
So, of course, Your Honor, of course. So what Judge Wise decided was that force majeure and the implied covenant should rewrite the terms of this contract. And the reason I'm emphasizing the terms is because you cannot analyze those two issues without a clear understanding and analysis of what the contract itself required. And that's unfortunately what Judge Wise did, divorcing what the court very clearly.
So basically, Oakland's highly paid lawyer, this person does not work for the City of Oakland. As you saw, she worked for a law firm that we paid a lot of money for, basically saying 35-page decision, yeah, the judge is all wrong. The judge doesn't know what the heck they're talking about. And neither do you 3 judges. I know what I'm talking about. And we're going to get to more. We're going to break down exactly how the city's argument is flawed in my closing monologue. But I want you to see this yourself, because you're never going to see this on the news. And no one ever shows you exactly how bad the City of Oakland is getting their butt handed to them in court. Ryan Richardson just lies to everyone and tells you everything's going well. So, this is really for Oakland's city, elected officials, city council. If you're a city council member, or you work for a city council member, or you know a city council member, send them this video, because Ryan Richardson is lying to Oakland City Council and telling them that we're winning these lawsuits even though we lost, and now we're on appeal, and the judges obviously are not very happy.
Clearly thought the city should have done to help after the federal litigation ended in OBOT's favor. The message in this 90-page opinion very clearly, Your Honor, is the city should have done more to help this project move forward.
Well,
But
it's not just that, but that's part of it.
Well, the court's ruling is based on the May 15th, 2018 time period to August 20th, the deadline. So May 15th is when the federal decision came out, and the August 20th is the deadline. It's a few months at the end of the performance period. The court found force majeure in that time period, and then basically excused OBOT's failure to meet the contract deadline based on the events in that time period. Here,
Well,
and that's why it's
and I don't want to jump ahead to your bad faith. I don't know if you're going to argue the bad faith case of this or not. But, and I know you contend that there's no bad faith, and you make
yeah, there was
similar
bad
arguments,
faith.
I guess. But how is it, or maybe I shouldn't ask how is it, but the judge found at least, and find, there's at least 12 mentions in her statement of decision of bad faith or breach of the covenant of good faith and fair dealing. And I mean, give you an example, Witkin describes the covenant of good faith and fair dealing as essentially that says if cooperation is necessary and one side in essence conducts itself to prevent the contract, there's an implied covenant of good faith and fair dealing that in essence is breached. That's how he describes it, and the cases are similar. So, for example, the judge, listening to all of the testimony and to Mayor Schaaf, among others, one thing she says is there's a resolute trajectory toward terminating the lease. And she cites all sorts of things. I mean, 6 bullet point force majeures. And as I say, I don't know if you're going to get to any of them or you're just globally going to say that they had a reward and they bargained for it all and it's all their fault. I guess that's your position. So they
That's
take
OBOT's
issue.
fault.
Wow. So let me first explain what a force majeure is for those of you who are sort of trying to figure that out. Force majeure means superior force in French. It is a contractual clause that relieves parties from liability if an unforeseen event makes performance of their obligations impossible or impractical. It protects against circumstances beyond their control, like natural disasters or war that could disrupt business operation. And so now that you have an understanding of what force majeure is, let's listen to basically the city is trying to recycle the exact same argument. As creative as they are, they're essentially trying to claim that they're the landlord and that the OBOT had a responsibility to deal with the regulatory agent. The issue is the City of Oakland is both the landlord and the regulatory agent. It's not like I rent a restaurant and I get the restaurant and I can sell food. It's like I rent a restaurant from a owner and I'm ready to open up a burger joint and I go to you and I say, hey, I'm going to rent your restaurant and I'm opening up a burger restaurant. And here are the things that I need. I need a grease trap because they're going to be frying stuff and there's going to be a lot of grease and oil. I need a grease trap. And that's part of your lease. Then all of a sudden, after you've signed it and you're ready to move in, the landlord says, actually, we're only going to allow vegan restaurants from here on out because we no longer believe the animals should be killed. And because of that, they changed the regulation on their building and tell you you're in breach of lease because you never opened your restaurant. Now, that's a pretty quick and dirty shooting from the hip analogy, but I think it describes exactly how egregious it is what Oakland's doing here. So I'm going to continue to allow just to hear the back and forth between the lawyer and the city of, and the judge here, but it's really bad. He rips him a new a-hole.
With your reading of Tagami's testimony, but assuming your reading of it is right, that admission, that's what you call it, an admission, has to be accepted by the trial court and is dispositive of this case that's existed for years now and weeks in trial and the judge's decision. And that's the end of it because Tagami said it's late.
Just like the admission in Stone Brewery was the end of it because they could have paid the rent anyway. in that force majeure case, yes, Your Honor, that should be the end of it. That is dispositive. And Mr. Tagami also
not
admitted,
dispositive.
Your Honor, that they could have built this thing. There were lots of ways to move it forward, and they did not do that. That's not force majeure. That has never been force majeure.
You
Or
didn't
it
move
started.
forward with the burger restaurant.
But that's not the law
Make it
anymore,
vegan.
and you should know that, Ms. Leonard. I mean, we don't need to get into it here, but
Oh no, I want to get into it. Hold on, let's rewind now.
Ms. Leonard,
Who said-
Mission in Stone Brewery was the end of it because they could have paid the rent anyway. In that force majeure case, yes, Your Honor, that should be the end of it. That is dispositive. And Mr. Tagami also admitted, Your Honor, that they could have built this thing. There were lots of ways to move it forward, and they did not do that. That's not force majeure. That has never been force majeure.
or it started. But that's not the law anymore, and you should know that, Ms. Leonard.
Miss Stain,
I mean,
you should know the law, lady.
we don't need to get into it here, but the Supreme Court of California back in the 40s said, quoting the restatement 454 at that point, that it was impracticable, and for what it's worth, and I'm sure you're aware of this, the current view of force majeure is much, how should I put this, more liberal than it used to be.
I don't agree with that, Your Honor. And in Stone Brewing, the case from this division of this court, the court said, although a force majeure provision is often included in a contract to specify which qualifying events will trigger its application, the qualifying event must still have caused a party's timely performance under the contract to become impossible or unreasonably expensive. That's this division of this court.
Unreasonably expensive doesn't sound like impossible.
No, that's fair, but that's not the argument here.
Mr. Schatz.
Good morning, Your Honors. May it please the Court, Ben Schatz of Manat, Phelps, and Phillips for the respondents, OBOT, Ogre, and CCIG. Like the appellant, I think I'd like to start with the story because the story is compelling.
Before we let him tell the story, I think it's just great that you actually hear from OBOT's lawyer themselves. I want to make a few mentions of, at this point, we're probably close to $20 million in the hole for lawyers like the one that you just saw, who continue to regurgitate failed arguments that have miserably failed. Did I say failed? I can't say fail enough because the city of Oakland is failing with our taxpayer money. But this is a deeper issue of just how this is not a good argument. It's losing. Why are we in appeals again? We're going to get back to that a little later, but let's hear OBOT's lawyer walk you through their version of this story.
Here, and also to point to a large document. The city contracted with OBOT to build a bulk terminal. Millions of dollars were invested, lots of time and effort were put into it. But then for political reasons, the city changed course and decided to sabotage the project. And in a 95-page decision that Justice Richmond mentioned, the trial court spelled out exactly how the city created delays, making it impossible for OBOT to meet construction deadlines. And specifically, it started with the coal ordinance, but it goes well beyond that. And then you heard a minute ago, the appellant said, well, OBOT says that there was no feedback. No, the judge says there's a court finding. All of these are factual findings. No meaningful feedback on the basis of design.
Do you disagree with Ms. Leonard's assertion that basically OBOT knew about, that the evidence showed OBOT knew about the uncertainty about coal before the lease agreement was signed? And does that matter?
I don't disagree. The city, I'm sorry, OBOT was aware that there were these issues. I mean, there's no question that was out there. But no, it doesn't matter because, I mean, that's the federal case, right? We had a whole federal case all about the no coal ordinance. But beyond that,
which they won.
After that, all of these other things happened, failing to allow access to the rail yards, failing to take efforts to make the rail access agreement, failing to complete public improvements, failing to turn over, I mean, essentially failing to diligently advance the project at all, and instead ultimately take steps to terminate the lease. So the city creates all of these barriers and then says, oh, you missed it, and so therefore you lose. And
they created these barriers because No Coal in Oakland and the Sierra Club were basically strong-arming anyone who ran for office, demanding that they sign this pledge. No Coal in Oakland also launched an extremely expensive and extensive PR campaign. I mean, we've gone through this on previous episodes, so I'm not going to do it again. We're just reviewing this case here, but go back and watch other episodes I've done about this bankruptcy case where we look through No Coal in Oakland and how they operate. It is absolutely reprehensible that they've been, I mean, it's a great story. I signed the pledge when I ran for city council in 2020. I live in West Oakland. Nobody likes the history of asthma and all of these things that are related to, I would say environmental racism, but it's actually environmental classism. And again, we've covered this before in previous episodes, but yes, there is environmental classism. Yes, poor people do end up in a toxic waste dump part of town. But we've been shipping coal to Richmond this entire time. There were no coal deals on the table. There were covered car deals on the table. Recently, and this is new news, no one knows this yet, but there was a multi-year study showing our area that had coal being shipped uncovered, and it showed no changes to the air quality. I'm not going to go down that rabbit hole, but this was pure ideology. One more thing I'll add before I get back to this. I don't see the Sierra Club. I don't see No Coal in Oakland. I don't see any of the organized environmentalist movement saying a single word about data centers. Data centers are probably the most energy-hungry creation, besides building critical infrastructure, ever created in the history of known mankind. These data centers are basically taking whole grids worth of electricity for a purely elective function. We don't need to take everything that we buy, say, do in our cell phones and our Black Mirrors online and take it and store it and run it through algorithms so they know exactly how to target us. These data centers are there to sell us things. They're there to use our information and basically create products and sell us these products, whether it be politics, physical goods, etc. Basically, we do not need data centers. They are not essential for the survival of humans. They're not essential for us running even a modern city. They are purely elective energy uses. But yet, and it pales in comparison to coal, and yet not a single peep is uttered by these environmentalist movements globally about data centers. Anyway, back to the video.
trial court recognized this was a lose-lose tactic. And the law has a name for this sort of behavior, and Justice Richmond pointed it out. It's breach of the implied covenant of good faith and fair dealing.
Bad
And
faith
this was a major project. It was a
bargaining.
joint venture, and there had to be cooperation. The city had a duty not just to refrain from making it impossible, but a duty to help accomplish the contract's purposes. And it didn't do that. And the law and the contract have a way of dealing with it, and that's force majeure. And the evidence that the city opposed OBOT's development was overwhelming. The only reason that the terminal hasn't been built today is because of the city's obstruction. So was there assumed risk? Well, certainly there was assumed risk. There's always assumed risk in contracts. But no contracting party expects sabotage. You know, the law and the contract require commercially reasonable efforts, not the opposite of that. And so OBOT certainly didn't assume the risk that the city would try to breach the contract and stymie the contract at every turn. That's not the sort of risk. You don't assume risk of an illegal, unsupported ordinance and then everything else that happened. You know, you don't assume the risk that the other side is going to breach the agreement entirely and terminate it. Justice Richmond made the point that the trial judge here found many instances of misconduct that triggered the force majeure provision. And he pointed out that, well, gee, if you only have one of them, well, that's enough. That gets us to where we need to go. And he's correct.
If you only have one of them, that's enough. I think they found 11. There are multiple instances documented, proven as fact in court, that the City of Oakland operated in bad faith in this deal. This is our taxpayer money they're playing with. I need you to remember that.
So that
And we're
even if
facing
the city is
bankruptcy. I
able
need
to
you to remember
somehow
that.
wriggle out of one of these points, and I don't see that, it doesn't matter because there are so many things that happen. And the trial judge's decision was so detailed. This is an enormous record, right? There's 56 volumes of materials. Every single document is enormous. But if you're going to read one item from the record this year, read the statement of decision because it is devastating from the credibility determinations that it makes down to the details on every single one of these points. And it's really, that should be the beginning and the ending of this appeal.
Probably will be.
The city is trying hard to come up with some kind of a legal issue to get out from under this, but there is no escaping the impact of what the trial judge found and the way that the trial judge correctly applied the contract terms.
I have a question that's not really in this case, I guess, but it's interesting, and maybe I should ask Ms. Leonard too.
This is a good one. We're
But
going to wrap up.
assuming one's view of the covenant of good faith and fair dealing is the way I described it, at least how Witkin describes it, and the force majeure provision provides, as the one did here, including acts of the other parties, can one make a case that if there's bad faith, it's per se a force majeure violation? I realize no one's asking that. It's just a question I have, if you've ever thought about it, since you seem to be finished.
I think that's a sound analysis and would apply equally here. But of course, every case needs to turn on its facts. So there's
The judge is basically saying, wouldn't bad faith in itself be a force majeure trigger? And I can't wait for you to hear the city's answer.
probably a way
Fair
to take
enough.
that analysis in any case and apply it. And here, it certainly fits. I mean, there's no question that all of these detailed misdeeds by the city were done in bad faith. And the trial court was very clear in specifying that at each step of the way so that the carefully crafted opinion holds together entirely.
In the context of breach of contract claims, Your Honor, there is no such thing as a bad faith tort. And the
I'm sorry,
implied-
I didn't hear the last thing. There's
There is
such
no
thing.
such thing as a bad faith tort. And the implied covenant serves a very specific purpose according to the Supreme Court of California, and that is to protect the parties' contract terms that they agreed to. And the fact that the court below wrote a very lengthy opinion doesn't mean that the court didn't make mistakes and didn't commit legal error.
I mean, I don't know what the right word is, the Capio memo
Here we
is
go.
a piece of affirmative action, right? The judge was not terribly impressed with the Capio memo, other than the reasons given by the city she rejected and found them to be disingenuous. Their position is they needed something back, and your position is, well, inaction. It's just inaction. We do nothing. We do nothing to cooperate. We do nothing to answer their questions. We do nothing to respond to this. We do nothing to respond to that. And then I guess you throw up your hands and say, it's all inaction. It's all their fault.
They must comply with the requirements of
So basically, the judge is saying the city, no coal in Oakland, they meddled. They did all sorts of things. I'm going to have Judge Brenda on again to talk about what she's heard when she was running for city attorney, how they basically bragged to her that they leaked the details of this deal illegally out at the no coal in Oakland and came up with this sophisticated way that they thought they were going to sabotage this process and somehow claw the land back that they signed the lease for with OBOT. It's absolutely disgusting. I'm going to let's just wrap up and then get my closing thoughts.
6.2 in order to meet their obligations. And this, what the trial anticipated, I will conclude by saying, this is the deal. And OBOT agreed to this deal, eyes wide open, and it is far past time for this land to be returned to its rightful owner for the benefit of the citizens of Oakland.
Thank you, counsel. We appreciate the arguments.
Judge Wise's 95-page ruling is a legal beatdown. 12 documented examples of bad faith. Remember, only one is needed for force majeure. The city's lawyers relying on cherry-picking testimony, but completely ignoring the city's sabotage. The 2018 federal ruling gave OBOT a green light, then Oakland buried it in tape. In this appeal, a last grasp. Every single court has ruled against the city. So what's my take? Oakland sold OBOT a dream, and then they pulled the rug out for political clout. This was never about cold. It was about cowardice, cover-up, and the city hall allergic to accountability. The West Gateway site sits empty, a stark reminder of Oakland's broken promises. Remember, this isn't just a contract dispute. It's a betrayal of trust that could cost the city dearly. If Oakland loses this appeal, and let's be real, we've lost every single legal round so far, the financial fallout could be brutal. We're talking tens of millions of dollars in damages. We didn't have to pay legal fees the first one because it was a development agreement that doesn't come with legal fees. But this is a landlord-tenant dispute where legal fees are available. That means Oakland's on the hook for OBOT's legal fees if the court sees fit. That's tens of millions of dollars. Now we'll know the appeals outcome in 90 days or less from the time of its trial 2 weeks ago. So give or take maybe 80-something days. Now Oakland may try to take this to the California Supreme Court, but good luck with that. They take less than 2% of cases, and they rarely take contract disputes like this. The city's running out of lifelines. We don't have many left. It's time to move forward. It's time to sit to the table and make a deal. We can't do this. Oakland wore two hats to this deal. We wore the hat of landlord, and we wore the hat of regulatory agency. They tried to conflate these roles, hiding behind their regulatory power to sabotage OBOT's lease, holding back permits, stalling approvals, refusing to cooperate. That's not negligence, it's sabotage. The court saw through it. They triggered the force majeure clause because Oakland's actions made OBOT deadlines impossible. You cannot play landlord and then use your regulatory muscle to tank the deal. That's bad faith, plain and simple, and every single court has called it out. And I've been calling it out here in Gotham Oakland. So, cold-fired lies, Oakland's billion-dollar breach of a good faith that could have brought revenue, jobs, and more to the city of Oakland, all for an ideological stand that's going to end up with coal being shipped through the city anyway. So maybe we'll be bankrupt by then. Demand better. Brian Richardson, Barbara Parker, your actions are inconscionable. You guys should be disbarred. You should lose your legal licenses. You have absolutely acted unethically, and hopefully one day you get what you deserve. Peace, y'all. This is Gotham Oakland. Please share this episode far and wide. It's very important. And again, if you work for the City of Oakland, you have no excuses now for your ignorance. You have to know we're going to lose this case. Thank you.
Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here. Yo, I swear it's only up from here.